Welcome back to the Supreme Court of the United Kingdom, where this afternoon we are continuing to hear the appeal in the matter of G and G. Reporting restrictions apply in this case. We're currently hearing the submissions by Mr. Devereux, Queen's Counsel, on behalf of the respondent father. Mr. Devereux.
The Lords, in my opening remarks, I sought to draw the Court's attention to the real concern, a very considerable concern, that applications made under the 1980 Hague Convention might be frustrated by unscrupulous parents making applications for international protection. And that real concern, the Court will note, is shared by the interveners Reunite being the leading charity that assists individuals who have either abducted or are subject to abduction proceedings, and indeed the International Academy for Family Lawyers and the Centre for Family Law and Practice. And we would submit that it's unarguable, without having to descend into any form of statistical analysis, that there has been an increase in the number of cases where asylum issues have arisen in the context of international child abduction cases. The Court will recall that the 1980 Hague Convention was incorporated by virtue of the Child Abduction and Custody Act 1985. We have that within the bundles of authority. It came into force in this country on the 1st of August 1986. In recent times, there have been a number of authorities that have considered and have been concerned about issues relating to asylum. And I wish to list them, though not take your lordships to them, in no particular order. The decision of Mr. Justice Hayden, F and M, that's at EF 1392. The decision of Mr. Justice Mostyn, E and E, that's dated the 25th of August 2017, EF 1381. Secretary of State for the Home Department, and G and R, that's the decision of the Court of Appeal dated the 29th of July last year, EF 1468. And finally, the case of K, stay of return order, asylum application, that's at EF 1810, decision of a Deputy High Court Judge, Mr. Darren Howe, Queen's Counsel. In that last case, the case of K, the father, who had not succeeded in defending an application by a left-behind mother under the 1980 Hague Convention, applied for asylum for his son, on behalf of his son, for the first time, after a return order had been made and following permission to the Court of Appeal having been refused. And that is one example of what might be described as a tactical approach, utilizing the potential conflict between the rules and principles that govern immigration law and the rules and principles that determine cases under the 1980 Hague Convention, or indeed, as I've sought to point out prior to lunch, cases which involve the summary return or the return of children under different auspices, whether that be under the inherent jurisdiction of the High Court or whether it be pursuant to the recognition and enforcement procedures of the 1996 Hague Convention. It's right in that context that the court is reminded that in this case, and I put this neutrally and deliberately so, but the court is reminded that in this case, the mother, as is recorded in her written case, which is at EF 164, at paragraph 18 of her written case, the mother in this case expressly requested on the 7th of December, but not in June when it was before the High Court, not in March when she made the application, not indeed in August when the matter was before the Court of Appeal, but as recently as the 7th of December, she requested that the Secretary of State consider the risk of harm to P in light of the reasonable likelihood that P, reasonable likelihood I should interpose, asserted that P would suffer harm if returned to South Africa. Now, as the left behind father, or those representing the left behind father, we don't have any ability to know what that letter said, what it referred to, nor indeed, of course, do we have any ability to know the real basis beyond the statement that this mother's put in the Hague Convention proceedings of her application for asylum. And we note, of course, that Mr. Hussain suggests in his note that the left behind parent should be given an opportunity to contribute to the asylum process, and indicates that, subject to an appropriate balancing exercise and determination, that the left behind parent should be able to have an understanding of the basis of the asylum claim. But so far, as the reported authorities show, there is no right for the left behind parent to properly engage in that process. And indeed, one of the real areas where delay has proliferated is as a result of disputes that have arisen between the Secretary of State and a left behind parent in Hague Convention proceedings seeking disclosure of the asylum file of the abducting parent. And what tends to happen is the file or disclosure of the file is sought by the left behind parent, and the Secretary of State resists that, perhaps on principled grounds of confidentiality or the fact that it's asserted that the party left behind would in some way be a persecutor or would disclose the information to an asserted persecutor. But that is an example of satellite litigation that, again, delays the proper and effective determination of a 1980 Hague Convention case. And whilst we endorse and are glad to see the suggestions by the UNHCR, that is certain, those suggestions are certainly not what's happening on the ground. What is happening on the ground, to put it bluntly, is delay. What is happening on the ground, to put it bluntly, is that the Secretary of State is not making good on its assurances. And what is happening on the ground is that therefore children are not being returned in circumstances where, absent an asylum claim, they would be.
Mr. Deborah, I think that at some point the court would be assisted if you, and indeed Mr. Setright, were able to provide us with proposed directions in the Hague Convention proceedings, in general terms, in hypothetical Hague Convention proceedings, which might address some of these issues.
We certainly will.
I raise it at this point. It's a matter we can return to.
Thank you. And it's something that,
Mr. Deborah, I'm interested in making sure that at the very first hearing, Guardian is, a direction is given that the Guardian has access to the immigration file, that the Secretary of State appoints the case to a specialist team. The Secretary of State provides, you can go on and on and on, but I would like some thought to be given as to how that aspect of the case can be absolutely tied down at the very start. So the directions are given as to the joinder of the Secretary of State and exactly the timescale the Secretary of State is going to take. Well, that, of course, only deals with the proceedings in front of the Secretary of State. It doesn't deal with how you deal with a potential delay caused by an appeal process. And I'd be very interested in hear what your solutions are to that. I can see the problems, but I don't, at present, if we turn our minds to what the solutions are, I would be extremely grateful.
Well, my lord, of course, and in a sense, I don't want to present the court with a load of problems without in any way providing some indication of solutions. But in order to do the latter, one perhaps has to identify the former. But Mr. Setright and I will endeavour to meet the challenge as best as we can. But delay is plainly a real problem. And I don't need to labour the point because your lordships have it very much in mind. But the recital to Mrs. Justice Leaven's order was pretty unequivocal, and it's difficult to think of a
Mr. Devereux, there should be a liaison officer between the Secretary of State and the High Court, for a start. There should be somebody actually with control in the Secretary of State of these types of applications. And standard directions, if mind is applied, potentially can sort out that problem. But I still don't see what the solution is to the appeal process.
At this stage, my lord, I don't have a particularly good answer to the solution for the appeal process, because this is a statutory process. And in a sense, well, presently, there is no ability to prevent the invocation of that statutory appeal process. And one could even see before the process itself has begun that, for example, requests for further time to provide evidence, or the application made on behalf of a dependent, and so on and so forth.
The standard direction could include a direction right at the very start that if the application for asylum is rejected, that the Secretary of State will within, say, a day or 2 days, make a decision as to whether or not there should be an in-house, preventing in-house appeals.
Well, we certainly would embrace all of your lordship's contemplated directions. And in this regard, on the facts of this case, we do point out that despite having the galaxy of talent that the mother now has, she hasn't actually applied for asylum for P. In terms of general principles, my lord, I want to turn...
I'm sorry, but what do we do to prevent that?
Well, my lord, that is a fundamental...
How do we, if it's an abusive process, what is the result? How does one prevent the Secretary of State from going ahead with considering it, or how does one control it?
Well, one controls it in the very way that is anticipated by your lordship, which is to provide, and it may well have to be backed up by a variation to the immigration rules that is carved out for Hague Convention cases, or cases that require the summary return of children, but a carved out process which requires the Secretary of State to take decisions by a certain date, albeit within the confines of providing sufficient time for the claims to be properly investigated, and for the particular parties to be able to put such evidence as that they wish to put before the court. Now, what Mr. Hussain is suggesting, which is again something we welcome, is that the left behind parent is given an opportunity to feed into that process. So the Secretary of State, because we know the Secretary of State in determining an asylum application should do so on the basis of the best information or the fullest information possible. That suggestion by Mr. Hussain and the UNHCR is something that we also welcome. But cutting across the statutory appeal process would be a matter for Parliament, on one view. But if I may come back to that without in any way avoiding that point, that would allow me at least time overnight to marshal my position so that it's refined and of more of assistance. Lords, what I seek to do is to analyse the particular directives that have been transposed into domestic law, but before doing so, because of course they're the key in one sense to this case, but before doing so, I do want very briefly, and I make that clear, I do want very briefly to just consider the context and some of the fundamental articles of the 1980 Hague Convention, appreciating as I do that your lordships will be familiar with the convention. I know that Lord Stevens is particularly familiar with it, but your lordships will be. Perhaps I could identify some particular points that I wish to emphasize. That convention is at tab 2, which is EF 468 in the electronic bundle. And Lords will see that the convention is preceded, the articles of the convention is preceded by recitals. The convention seeking to protect children internationally from the harmful effects of their wrongful removal or retention and to establish procedures to ensure their prompt return. Article 1 sets out the objects of the convention to secure the prompt return. Article 2, contracting states shall take all appropriate measures to secure within their territories the implementation of the objects of the convention. For this purpose, they shall use the most expeditious procedures available. The convention itself, by virtue of Article 4, applies to any child up to the age of 16. And the key to the convention is perhaps Article 12, but before one gets to Article 12, one finds oneself at Article 11, and that provides that, again, contracting states shall act expeditiously in proceedings for the return of children, and if they haven't reached a decision within 6 weeks, the applicant or the central authority of the left behind state, of the requested state, shall ask or have a right to request a statement as to why there's been a delay. The heart of the convention, Article 12, essentially requires, subject to the exceptions, that the authority, in this case the High Court of England and Wales, shall order the return of the child forthwith. And Article 13 then provides various exceptions to the rule of return. For the purposes of this case, the court will be aware that the mother seeks and sought to rely on Article 13b. That's to say that there's a grave risk that the particular child's P's return would, that the return would expose P to physical or psychological harm or otherwise place the child in an intolerable situation. In addition, she relied on the paragraph below, P's objections. The court may also refuse to return the child if it finds that the child objects to being returned and has attained an age and degree of maturity at which it is appropriate to take account of its views. Part of the route map that the applications under the Hague Convention are subject to requires, at the earliest stage, reasonably appropriate, the abducting parent to put forward there what have been described as defences, and that is why we know, Mrs. Justice Lever knew what it was that this mother would have run in respect of the Hague Convention proceedings. The interpretation of the Hague Convention is to some extent explained by the explanatory report to the Hague Convention. This is right, referred to it. It's by Professor Elisa Perez Vera. It's at tab 72 of your Lordship's bundle.
We're all working off the electronic bundle, Mr. Devereux.
And the page is EF 2983.
Thank you.
At electronic page 2993, there is paragraph 40. That paragraph under the heading Relations with Other Conventions says, the convention is designed as a means for bringing about speedy solutions so as to prevent the consolidation in law of initially unlawful factual situations brought about by the removal or retention of a child. In addition, can I take you to paragraph 104, page 3014 in the electronic bundle. The importance throughout the convention of the time factor appears again in this article. And then on page EF 3015, top of the page, second sentence, there is a double aspect to this duty. Firstly, the use of the most speedy procedures known to their legal system. Secondly, that applications are, so far as possible, to be granted priority treatment. And that has been reflected again in the procedures that have been adopted by the High Court. As I said before lunch, we are leaders in our field in the interpretation and application of the 1980 Hague Convention. We are looked upon by other signatory countries. Other signatory countries follow our lead. The domestic procedural code that is provided to support expeditious application and progress of 1980 Hague Convention proceedings reflects the requirements to the letter of ensuring that these cases are properly and expeditiously determined. And looking for solutions, it may well be that one of the solutions requires some further rules within the family procedure rules to deal with cases of this nature. The domestic procedural code is the family procedure rules, and I draw your Lordship's attention, without taking your Lordship's, to rule 12.481, that's electronic page 3192, rule 12.49, that's in the supplementary bundles, electronic page 3194. Forgive me, these are all in the supplementary electronic bundles. So the first reference was supplementary electronic bundle 3192, second reference 3194, and third rule 12.51, which is in the supplementary bundle at 3194. The need for expedition is also reflected in the practice direction to those procedure rules and in the practice guidance, which supports international child abduction proceedings. That's in supplementary electronic bundle 3224. And the Court of Appeal refer to all of this in comprehensive terms, hence my disinclination to take your lordships to those tabs and those particular materials. That's not to say that they're not important, because they are. I'm just trying to use the time available in the best way possible. The court will also appreciate, and it's an important point that we make in the context of rights, that there is an obligation, a clear obligation on the state that derives not from the principles of the 1980 Hague Convention, but derives from the principles that are contained within the European Convention, to bring about the return of children who have been wrongfully removed or retained in an effective way. And in that respect, I'd like your lordships to travel to electronic bundle page 774, which is the case of Carlson in Switzerland before the European Court of Human Rights. That's a case that sets out a number of principles at electronic page 774. That's paragraph 69. The principles are recorded as emerging from the case law of the European Court of Human Rights are summarized there, page 774 in electronic bundle, Carlson, Switzerland. It records that there are, in addition, positive obligations inherent in an effective respect for family life. Then subparagraph Roman numeral 3, as regards more specifically the state's obligation to take positive measures, the court has repeatedly held that Article 8 includes a parent's right to the taking of measures with a view to his or her being reunited with his or her child, and an obligation for the national authorities to take such action. And then subparagraph 4, the crucial point is therefore whether the domestic authorities have taken all the measures that could reasonably be expected of them to facilitate the exercise of rights of custody, parental responsibility and access that a parent is recognised as having under the applicable law or as a result of judicial decisions. Of course, the difficulty about the points of principle that arise in this case are that whatever is decided, it may apply, it will apply, forgive me, across a spectrum of cases. One of the hypotheses that has been put forward, for example, by Lord Leggett, was this: why simply don't you treat a dependent child as a claimant from the beginning? And there is a superficial, we would say, for reasons that we will seek to articulate, there's a superficial attraction to that. It provides plainly the protection to the child, and there cannot be any risk of the state refooling the child and breaching the child's rights. But what might one ask, and I hope not too rhetorically, because this is the wrong place to utilize that form of argument, but what might one ask, or what might one contemplate if a parent wrongfully removes a child from country A and travels to country B? Now that parent has really, as a matter of objective assessment, very limited links to that particular child in country A. That parent may not be the primary carer. That parent may not indeed be exercising any real, what might be described as contact with the child. So a very different case to the case that your lordships are concerned with. If in those circumstances, the child was simply defined as a claimant from the beginning, then the child would simply not be able to be returned at all for the whole period that the claim was being determined, which of course, as we've seen before lunch, could be up until the hearing of any appeal in this court. Now, there are other, I seek to develop objections to the formulation that has been contemplated, but that in stark terms is something that is of real concern. I want with that diversion to return to the case of Mamuzu and France, which is in the bundle at page, in the main electronic bundle at page 1023, which is, for those who are using a paper copy, tab 23. It's 993 is the beginning, and I want to take you to page 1023, because again, and this case is later than the case of Carlson in Switzerland, there is a illuminating, potentially, discussion of the principles that relate to the conditions of enforcement of the child's return, as is identified at paragraph 82 of that case. And can I ask your lordships just to read paragraph 83 for a few moments? And your lordships will see that just before the bottom of that page, it says, lastly, in this kind of case, the adequacy of a measure is to be judged by the swiftness of its implementation. And proceedings relating to the award of parental responsibility, including the enforcement of the final decision, require urgent handling, as the passage of time can have irremediable consequences for relations between the child and the parent with whom it does not live. The Hague Convention recognises this fact because it provides for a range of measures to ensure the prompt return of children removed to or wrongfully retained in any contracting state. And it's right, we would say, of course, to reflect again upon the potential for irremediable consequences in a case such as this. Both generally, if refugee status is granted or if a claim is processed, then that will necessarily potentially affect very significantly the relationship that the left behind parent will have with the child. But in this case, what are the consequences? Well, I've identified them. The father's not conducting a relationship with P as he had done previously. He doesn't know where P is. He doesn't know where P school is. And there seems no prospect that he is any closer in reviving, re-establishing the loving and close relationship that he has. Even at the end of Mr. Payne's submissions, and undoubtedly Mr. Payne was doing the best that he could, but even at the end, he was not able to provide this court, the highest court in the land, with any defined date or any backstop date even, when the decision would be made. And in the context of the assurances that the Secretary of State gave to the Court of Appeal, that is a matter of very considerable, it might be thought, concern. The Court of Appeal, in this case, analysed the convention and the the rights engaged under the European Convention in a way that we submit is comprehensive and beyond challenge. And I don't seek to require the court to indulge me in any further time in relation to the Hague Convention. In respect of the Geneva Convention and the status of refugees, there is, in fact, as I think Lord Leggatt pointed out at the very start of this hearing, very much common ground between the parties. That much is clear from the written cases, and that much I would respectfully submit is clear from the oral presentations. And what seems to be the centre of this appeal, on one view, is the extent of the Secretary of State, in the context of a 1980 Hague Convention case, to investigate a potential asylum claim by a child, and whether the procedural safeguards that are in place or are suggested to be in place are sufficient to protect that child from a risk of refoulement. All of that, of course, falls within the context of the requirements and the obligations which seem to be accepted by the parties, that the state should expeditiously process and determine claims subject to Mr. Setright's objection to the determination, but should determine claims speedily. And one can contemplate in that regard a spectrum of potential positions between 0 and 10. And let me put it this way. At 10, you have a formal application. And I think it's accepted if there's a formal application by a child, then it's required to be investigated. At 0, you may have absolutely no application and no request by a child or anybody else on behalf of the child. And I think it ought to be, and appears to be, both on the part of the appellant and by the UNHCR, that there can be no duty to find the needle in the haystack, no duty to investigate. The difficulty that presents itself in stark terms in this case is where between 0 and 10 is the right point reached. Where indeed does the child, where is it that the child is properly protected? And we will seek to identify that point in, I hope, due course. But before we reach that point, I do wish to make a further remark in relation to status. And again, within the context of what is agreed, we certainly agree the difference between the provisional rights that attach to refugees prior to status being granted, and we accept the difference between the recognition and the fact that the individual has rights prior to recognition. And we identify those as provisional rights. I think Mr. Hussain identified them as presumptive rights, but plainly they are rights that inure within an individual. One of the difficulties that we have identified in this case is the fact that the practice of the Secretary of State appears to be to grant individuals what they term as refugee status when they are not in fact refugees for the purposes of the Convention. And we can identify that, we suggest, by going to the case of JS, Uganda, and the Secretary of State for the Home Department, which is electronic page 1619. That's tab 38 for anyone using the hard copies. And if I could just take your lordships to the head note and invite your lordships just simply to read the head note. A person could not, it was held by the Court of Appeal, derive refugee status from the refugee status of another person. It followed that a person who is admitted to the United Kingdom under the Secretary of State's family reunion policy by reason of a link to a recognised refugee did not thereby himself acquire the status of a refugee under the Convention. That practice is reflected, and we say it's a wrong practice having regard to the Convention, but that practice is reflected in the Asylum Policy Instruction Manual that we've looked at and Lord Stevens latterly considered and discussed passages from. But if we could return to that manual, the May 2014 manual, it's...
Mr. Devereux, before we leave this, we were taken, I think, to a paragraph in the judgment of Lord Justice Underhill, which distinguished the situation where the dependent might have an independent basis of claim, even though it wasn't advanced.
Yes. Could your lordship just indicate which particular passage?
I'm looking for it as we speak.
Ah, I'm so sorry. You were asking me whether I could find it.
It's 190. It's paragraph 190.
Yeah, it's right at the end. Yes. No, and your lordship's identifying the last sentence, I think.
Yes.
And it's a theme of my submissions that I don't seek to shut out individuals who have proper claims. And I want to develop that in relation to the specifics of the procedures directive in due course. And again, if one just reverts to that theoretical spectrum of 0 to 10, I'm certainly not at 10. Lord Legate.
You're dangling in front of us the prospect you might make a submission sooner or later about where on the scale of 0 to 10 your position is. It
Yes.
might be helpful to know quite soon what exactly your case is as to where the non-refoulement protection kicks in.
Yes.
And we'll at least know what the target is.
Well, my lord, I was trying to keep you, if you like, attracted by the prospect of something coming. But in the event, I can provide that indication now at your lordship's proper invitation. My lord, what we say is that the key to this is within the procedures directive, and the point between 0 and 10 is the point whereby it can be understood that a request is being made for international protection. If the Secretary of State or an official is undertaking duties on her behalf, applying a proper objective test, decides or determines that it can be understood that a particular individual, whether adult or child, is making a request for international protection, then there should be a right not to be refooled thereafter. And that, Lord Stevens.
I thought that was exactly the same position as the appellants.
Well, it isn't exactly the same position as the appellants, because the appellants, we say, pitch in very considerably lower. They're closer to 0 than they are to 10. We're closer to 10 than they are to 0.
They say maybe, whereas the procedure directive says can be understood to be.
Yes, and I
uh,
seek to adopt what the procedure directive says, rather than what I suggest respectfully, whether this is entirely helpful or not, is that the appellant's position is closer to the needle in the haystack. The requirement, the obligation on the Secretary of State to hunt down a potential claim, the hidden claim. We seek to characterize it in a different way. We say that the obligation, the underlying obligation should be on the particular applicant to come forward, but it doesn't need to come forward in any formal way. That request can be made in any way that doesn't meet the administrative requirements.
So presumably you accept, Mr. Deborah, that it's been triggered now since the letter was written in December?
Well, my lord, I can't go as far as accepting that. On one view, I could have not drawn your lordship's specific attention to the letter of the 8th of December, but properly I did so because it's part of the context of the case in terms of why was that brought to the Secretary of State's attention in December rather than, for example, in March, June, or August. But secondly, I don't know the content of that letter, and I simply don't accept that would trigger. It may do, it may not. I'm not suggesting that it doesn't, but I can't actively accept that it does. But what I think
I put, sorry, to Mr. Hussain was whether taking the starting point as being that it can reasonably be understood that there's a request for protection, you wait until the caseworker has studied the application and takes a view about that, or whether there's a presumptive position that where an application is made by a parent for herself and a child as a dependent, the child is to be understood as making such a claim, unless it appears otherwise.
Well, that's closer to the 0 point, my lord, is it not? And also, it ignores.
Well, that's not my scale, but Mr. Hussain's argument was it's presumptive.
And I don't accept plainly Mr. Hussain's position. I understand the way he puts it, and I understand some attractive points to it, but it would place. It's not met by the requirements of the procedures directive, whether in its present, whether in the form that we've accepted, or indeed in the form that has been developed. And also, it would provide a level of protection to people who might not necessarily fall within the principles of non-refoulement, but also would be, obviously, it would render the ability of left behind parents to return children to be impossible.
Well, the trouble is that you accept that all that's needed is to sign a form in the name of the child, and then the thing is triggered. So I don't at the moment understand what it serves you to be strenuously arguing that that isn't the effect of the application that's been put in, for example, in this case.
Well, it serves me in this way. At some point, one has to establish what how something is engaged. So plainly, I accept as a matter of interpretation of the procedures directive that the signing of the form would be sufficient. Prior to that, this court or a member state, has to draw the line at some point. And the debate that your lordship and I are having, and the debate that your lordships are having, relates to where the line is drawn within the context, for example, of a Hague Convention case. I mean, one option for this court is to simply adopt your lordship's point and your lordship's argument, which is to say there is a presumption, and all we can do, essentially, accepting that presumption, is to try and hurry everything along. But in the context of an appeal process that can go to this court, and the fact that there can be further applications, and that individuals throughout the process can, of their own motion, delay the process, that is going to deny a whole range of children who, on my, for example, who've been taken by parents who perhaps are unscrupulous, from being able to be returned.
Mr. Devereux, where the line is drawn may well be terribly academic, but what's not academic is how you prevent the asylum procedure from frustrating the Hague Convention. And as much assistance as you can possibly give would be gratefully received, because that is a major focus of this case, to my mind.
Well, my lord, certainly I'll attempt to do that during the course of the rest of my submissions, and also happily overnight, your lordships have provided me some time, and I will very much put my thinking hat on to provide that assistance. And because the practical effect is what concerns the father as much as this court, and academic points are of importance too. My lords, I was developing a submission that sought to indicate that part of the problems that have bedeviled this case and potentially other cases is the fact that the Secretary of State appears to grant individuals who are not refugees status to individuals who are not refugees for the purposes of the 1951 Geneva Convention. And we had looked at the case of JS and the Home Secretary, and I wanted to return to the Asylum Policy Instruction Manual that we looked at and hopefully Lord Stevens discussed earlier. It's at EF 2247. And here is the example that lordships have looked at previously, but at page 2247, under the heading Section 4, granting or refusing leave in lie, Section 4.1, and there identifies that it's the practice, as Mr. Payne I think has accepted, that dependents will normally be granted leave of the same duration and status as the principal applicant. But we say that that practice is simply wrong. And we note, my lords, that in the letter, the standard letter that is being provided by Mr. Payne, which I think is contained in the supplementary bundle, the further bundle that was provided to the court yesterday, that practice is again identified. And I don't know whether your lordships have that extra bundle. It's not the supplementary bundle, it's the loose bundle that was not paginated. And it's page
additional materials provided on the 25th of January.
Yes, it's a page 109 of that bundle. If I could just take your lordships for completeness to that. So it's page 109 of the additional materials. And at paragraph 2, it obviously provides different options. But at paragraph 2, your lordships will see that it's recorded that the particular individual has been decided that as a dependent, they will be recognised as a refugee and granted leave until that date. That, of course, is a matter of concern to us in circumstances where it would prevent a return to another country, but also because it's inconsistent with the requirements under the Geneva Convention.
And you would say it's inconsistent with JS Uganda.
And it's obviously inconsistent, my lord, with JS Uganda. And it's obviously it's crept in for a policy reason, but it's not one that is, as I say, consistent with the four corners of the Geneva Convention. In relation to that convention, and in particular Article 33, could I take your lordships to EN, Serbia, and the Home Secretary, which is in electronic bundle 1362. It's tab 29 for anybody using the hard copies. Forgive me, 1336. At page 1336, one has the record of the facts. The head note is at 1337. That the part of the judgment of Lord Justice Stanley Burnton that I wish to refer this court to is paragraph 58. And this considers the position of the Refugee Convention within the law of England and Wales. And as again, between the parties, it appears to be accepted that the Refugee Convention is not incorporated. It's been given a status superior to the immigration rules. And then Lord Justice Stanley Burton at paragraph 58, page 1362, asks himself the question, for what purposes and to what extent has it been incorporated? At the bottom of that page, H on the side, so far as the Refugee Convention as a whole is concerned, Parliament has legislated in section 2 of the Asylum and Immigration Act, but it did not do so in terms that would give the Refugee Convention the force of statute for all purposes. And your lordships will recall that section 2 of the Asylum and Immigration Act is headed the primacy of the convention, and essentially requires that nothing within the rules should be done which is inconsistent with the convention. I don't need to take you to section 2, it's an electronic bundle, page 594. But the way in which the convention has been incorporated outside the qualification directive, I submit is summarised well by Lord Justice Stanley Burton. I'd like to take your lordships next to the opinion of Lord Bingham in the Roma rights case. That's at electronic bundle 1897. I want to take your lordships there because it provides, within the context of this case, I submit an interesting analysis of not only customary international law, which Mr. Hussain has rightly pointed out is not necessarily accepted by all academics, but also because of the particular issues that were engaged in that case. It's at electronic bundle page 1897. Lord Bingham's opinion begins at page 1917. But for the purposes of the development of my submissions, I seek to draw your lordship's attention to the passages that run from page 1930 to 1934. And particularly, I'd like to draw your lordship's attention to paragraph 26 and 27 and 26 and 27 at page electronic bundle 1934. And I raise this within the context of this case. Paragraph 26, there would appear to be general acceptance of the principle that a person who leaves the state of his nationality and applies, so there seems to be inferred there that there needs to be some positive step. This on the spectrum from 0 to 10 is somewhere above 0. Whether at the frontier of the second state or from within it, should not be rejected or returned to the first state without appropriate inquiry into the persecution of which he claims to have a well-founded fear. Lord Bingham then goes on to inquire whether there is a rule of customary international law and decides that there isn't. And just in relation to customary international law, Mr. Hussain, as I say, quite properly accepted that some academics do not accept that non-refoulement is now a matter of customary international law. In that regard, I don't need to take you there, but the distinguished academic Professor James Hathaway has provided an article which is within the authorities called Leveraging Asylum. And he, in that article and in his forthcoming book, develops the arguments against the argument that there is a rule of customary international law. And that's in the supplementary bundle at page 72, I think. In the additional materials, forgive me, in the additional materials that came before the court yesterday at page 72, I don't need to take your lordships to that, but that plainly is something that isn't agreed between the parties. What I do need to take your lordships to and do now is the United Nations Convention on the Rights of the Child. This has been referred to earlier. And for completeness, I seek to identify a number of articles for your lordships. It's at electronic bundle page 477. And I think the court is aware that this has not been incorporated, but it plainly ought to provide principles that ought to be followed. And in relation to this case, the court will wish to consider Article 3 That's on electronic page 478. Article 11, page 480, states parties shall take measures to combat the illicit transfer and non-return of children abroad. Article 12, obviously, states parties shall assure to the child who is capable of forming his or her views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child.
Mr. Devereux, this is not implemented in domestic law. So, first of all, on what basis do you rely on it? And secondly, for what proposition?
Well, I rely on it to the extent that I'm providing the court the maximum assistance in relation to potential international obligations, because you will recall that within the qualification directive that there is a requirement for member states to follow international obligations. But I entirely accept that it doesn't go particularly to any submission that I make, and it may be that your lordship is very politely moving me on to the qualification directive.
I'm not trying to move you on, really. I just want to know what the significance of this is. I mean, in a number of recent cases, the Convention on the Rights of the Child has been raised, and sometimes it is indirectly of effect, for example, because it's taken into account by the Strasbourg Court.
Well, my lord,
I was seeking to establish here what basis there is for us looking at it, and
the basis.
Secondly, which part of your case it supports.
It supports, my lords, my case in this way. In due course and very shortly, I will be identifying the procedural safeguards that are provided for within the recast procedures directive. And I shall be doing so to support my case that those procedural safeguards are sufficient. As part of the process by which the procedures directive recast has developed, there is express reference to the United Nations Convention on the Rights of the Child. So in seeking to persuade your lordships that the right answer to this case is within the four corners of the recast procedures directive that no one has yet taken you to, I'm going to show you a recital within that expressly indicates that the United Nations Convention on the Rights of the Child has been taken into account. And in that regard, I'm simply traversing some relevant articles. It may be a long run up to a splash, my lord, but that's what I'm doing.
When you get to the launching point, the recast directive itself doesn't apply in this jurisdiction, does it?
Absolutely right. And first of all, we didn't opt into it. But secondly, obviously, we've crossed the Rubicon. But what I seek to do is to answer the concerns about procedural safeguards that have been rightly identified by this court by reference to how our European friends have met those concerns. And I
think that would be of interest. If we could proceed to that, that would be helpful.
Again, without wanting to extend my run-up, I would like to run through the qualification directive as has been transposed and the procedures directive, but with the prospect of a splash point with the recast directive, if I may.
Right.
Finally, on the United Nations Convention on the Rights of the Child, I just simply refer your lordships to Article 22. States parties shall take appropriate measures to ensure that a child who is seeking refugee status or who is considered a refugee, so there plainly is a distinction potentially with a difference there, in accordance with applicable international domestic law and procedures, shall, whether accompanied or unaccompanied, receive appropriate protection and humanitarian assistance in the enjoyable of applicable rights. That within the context of, again, the procedures directive recast, as we're going to come to see, is, I suggest, important. Can I turn then to the qualification directive? That's at tab 6, and I know that your lordships have looked at this in very considerable detail, but to assist my submissions, I want to try and distill down my arguments on the foundation of some of the parts of this directive. And it also sheds light on the development that we'll later see in the recast directive. The qualification directive plainly delineates between particular individuals. It delineates between people who are refugees and people who are eligible for subsidiary protection. And also it delineates a further class of person, and this is at page EF 563, family members. And those family members, of course, include, and we see this at Article 2H, minor children. Mr. Hussain quite rightly took you to the chapter 7, which is the content of international protection and the general rules. But I do submit that the whole scheme and structure of this directive, as with the procedures directive, is a strict and carefully calibrated delineation between the benefits or the protections that accrue to particular classes of people. And that structure undoubtedly came as a result of very careful reflection and thought by the member states of the European Union to provide standards for which particular individuals could be given the protection that they need. For the purposes of my submission, as I have identified, the definition of Article 2G is critical, and that's to say that an application for international protection means a request by a third country national or a statesperson for protection from a member state who can be understood to seek refugee status or subsidiary protection status. So I accept, as I've indicated, that the formalities of a claim don't have to be lodged. There can be a simple request that can be understood to be a claim, but it must be a claim not for some range of protection. So a claim that requires protection in relation to the best interest of a child from a local authority or some other form of protection, but a protection that relates, well, seeks refugee status or subsidiary protection status. So the humanitarian protection as described by the immigration rules. The latest bundle, so that's the additional materials, provides, and Lords, that may be a moment just before we go to that, to pause and have a break. I know that your lordships wanted a break, I think, at 3:15.
Right, if that's a convenient point, we'll take 5 minutes. Thank you, Mr. Devereux.
Thank you.
Mr. Devereux. Question from Lord Burrows.
Yes.
Yes, Mr. Devereux, can I just take you back to your 0 to 10 scale, just so that I'm clear as to what exactly you're saying? As I understand it, point 10 is where you would be needing a formal application by the child. North is where there's no application or anything equivalent to an application by a child or anyone else. And you're somewhere in the middle. Now, does that mean to say that you are not seeking to uphold the reasoning of the Court of Appeal, because I would have assumed that the Court of Appeal, on the face of it, is adopting point 10 on your scale. Is that incorrect?
Well, my lord, I don't accept that necessarily, because the Court of Appeal, in their analysis, finds support in the terms of the Qualification and the Procedures Directive. That is, if you like, the core of their analysis. Now, if I'm right about that, my analysis finds support in the very same on the very same foundation. The only difference, and it's a difference with a distinction I accept, but it puts me pretty close to 10 on that spectrum, is that I accept, as I think I must, that a request that is made that doesn't meet the formalities of a claim, but a request that is made for protection does engage the protections. So forgive me for interrupting, my lord. It's the Court of Appeal's reasoning, but with a footnote.
But it might be said that the other side are also deriving their test as being grounded in the Qualification Directive 2G. I mean, their test, as I understood it, was that the Secretary of State is put on notice through an application by a parent that the child may have refugee status. That is, in a sense, their interpretation of what is meant by the Qualification Directive 2G can be understood that a particular individual is making a request. So it's not so much what one's grounding it on as how one is interpreting that.
I accept that. I accept that entirely, and that's their interpretation, although, of course, they don't seize upon Article 2G in that way. What they do is to, along with the UNHCR, is to refer to, amongst other materials, some of the reasoning from the European Court of Human Rights. But I mean, I accept that they could, if they wanted to. They didn't appear to me to be presenting it in that way, but they could say that their test falls squarely within the definition of Article 2G. I can't avoid Article 2G as much as I'd like to. It's there. And I accept that it's there because it plainly makes good sense. As a matter of fairness and effective access, it's plainly right that an individual should not have to, an individual who may be vulnerable in all sorts of different ways, whether that be a child or anybody else, would have to meet administrative hurdles. And we know from looking at some of the case law that when countries have put those hurdles in place as a means to avoid or regulate influx of individuals, whether a mass influx or otherwise, then those are regarded to be, in some circumstances, unlawful. So I accept that there must be, as a matter of fairness, the interpretation that I put, but I do say that that is consistent when one reads the Court of Appeal's judgment in its entirety with the way that the Court of Appeal found the case. And it is different. It's a different species to the test that my learned friends are urging upon you, which is closer to zero, closer to needle in the haystack, and putting a far greater obligation on the Secretary of State to undertake an investigative role.
And can I just press you on that? So if we could say various shades of opinion as to how you interpret 2G are possible, and therefore it's going to turn on the practical or the practical understanding of that. Your practical understanding, as I'm reading it at the moment, is that you translate that as requiring an application by the child or a formal request of some kind. Is that right?
Well, an application, certainly. I retreat from your lordship's inclusion of the word formal, because that is not the interpretation that I put on.
So what is it that you are exactly saying there?
What I say is that there has to be a request for protection made, and
By whom?
well, either by the parent or by the child, or on behalf of the child.
And that request can take an informal, can be informal, can it?
Yes, it can. And I was going to take your lordship and your lordships to the explanatory memorandum that provides an illumination, although Lord Legate has a question.
I just want to pin you down a bit further, Mr. Devereux. Suppose that the parent puts in the application for herself claiming refugee status and for her child as dependent, not in the child's name. And suppose that application doesn't make a request that the child should be independently given refugee status, but or recognised as a refugee, but it contains material which would reasonably put the Secretary of State on notice that there are grounds for considering that there may be a risk of persecution to the child as well as to the parent. Is that then to be understood as a request for protection which triggers the non-refoulement obligation?
Well, it may be, or it may not be.
So, well, who decides that?
Well,
we know whether the child can or can't be returned. Then do we have to have the court have to decide that on the application?
The Secretary of State is the determining authority for the purposes of the Qualification Directive and the Procedures Directive. So it would be for the Secretary of State to. I mean, it wouldn't be for anybody else. It would be for the Secretary of State to decide whether that constituted what could be understood to be a request for international protection.
Well, I don't understand that really, because if the Procedures Directive, if within the meaning of the Procedures Directive, that is to be regarded as an application, then the Secretary of State can't refoul, because that the legal protection kicks in as a matter of law. It's not the matter of judgment for the Secretary of State.
Well, the Secretary of State has to establish whether there is a request for international protection, in the same way that, for example, I think Mr. Hussain accepted that not every individual, of course, that comes to this country makes a claim or request. And so there has to be a delineation at some point of different classes of individual. The classes of individual may be those that make a formal application. There may be those that make a request that constitutes an application, and there may be those that don't say anything at all and don't want to make an application.
All right, well, we'll leave it there. Thanks.
I mean, I can see from it's a question, my lord, and I can see your lordships reflecting on this, but it's a question of the application of theoretical rights in the real world. And what the Qualification Directive and the Procedures Directive seek to do is to provide a set of standards that sought to advance a common asylum area. And in the real world, there have to be lines drawn as to the way in which, for example, particular benefits and protections are given. But I mean, I can see the theoretical position, but I'm seeking to meet the theoretical position with a set of procedural safeguards, and also understanding what happens in terms of the application.
Well, we might say the simplest thing in the real world is just to treat the application as one made on behalf of the child as well from the start, instead of getting into splitting very fine hairs of analysis about exactly when it comes into that category, or whether the process can start all over again when a later different form is filled in on behalf of the child.
I accept the attractiveness of that position, but it doesn't sit in any way consistently, if I may say so, with deference to the four corners of the qualification directive and the procedures directive, nor does it meet the challenges of a case where an unscrupulous parent seeks to frustrate the operation of the system by which children are returned to other countries. And your lordship,
the unscrupulous parent, at least if well informed, will immediately put in the application in the child's name anyway, so that these questions won't arise at all. I mean,
I accept that's your lordship's point about, well, that's the signing of the form. But I'd still return, if I may, to the point, because it cannot be overstated in my submission that it would erode, if not ruin, the convention and the rights of parents abroad if there is, if you like, an open road and a fast car by which unscrupulous parents can engage asylum procedures, and indeed months of asylum procedures and years of asylum appeals, to deny and to render hopeless the rights of parents left abroad.
Mr. Devereux, can you help me on this? It comes back to your spectrum and where different cases might stand in the spectrum. Looking again at subparagraph G in the definition of application for international protection, are you saying that there must be a subjective intention on the part of the parent or the child named in the application to seek the status of a refugee? Or is it enough that there's material in that application which would justify such an application?
Well, there plainly are different options there, interpreting those words, who can be understood. One option is the option that's contemplated, that there are both subjective and objective factors, and there's both a requirement for a subjective approach and then an objective assessment, or it's simply objective, which is the analysis by the decision maker of the material that's before them.
Now, do you say it's a subjective intention required?
My lords, I think that I would, yes.
Right.
But it's difficult. It's difficult in terms of a child.
Well, that was going to be my next question.
Well, I anticipated it, my lord, and my answer is that it's extremely difficult in relation to a child, because again, for all the reasons that are readily appreciable.
But nevertheless, you say that in order to constitute an application for international protection, there must be such a subjective intention, as opposed to material which would justify it.
Because, of course, we're dealing we could be dealing, it depends on how your lordships seek to reason it, but we're dealing with dependents per se. Dependents may not, of course, simply be children. They may be a range of other family members.
Yes, but we're approaching this in its general application at the moment.
Yes, but I'm just identifying that the principle could be then taken up by other individuals. Lord Stevens had a question.
Well, I was bringing you back to, I think it's electronic page 275, and to my Lord Burroughs's question, and that is the judgment of the Court of Appeal.
Yes.
Because that is at the top of that page, paragraph 81. The Court of Appeal referred to 2C, Article 2C, they don't refer at all to Article 2B, which is the understood to be application.
Yes.
And they rule out the they state categorically, unless you tell me otherwise, that there is a nothing in those provisions that prohibits the removal of a dependent of an asylum applicant who has no independent asylum claim of his or her own. They don't use the test of understood to be making an asylum claim. So I was reverting to Lord Burroughs's question, that is,
Yes.
you're not seeking to uphold the Court of Appeal's decision.
Well, my lord, the way that I put it is that I do seek, obviously, to uphold the Court of Appeal's decision, but I do so, if you like, with an explanatory footnote. And that explanatory footnote makes reference to Article 2G. And my lord, I was, but I accept, as I must, that obviously the Court of Appeal don't make reference to that. I can't seek to suggest that they do.
Well, can I ask you a second question, a follow-up question? That is, in the subjective intention, is it a subjective intention to put forward material, which then objectively is to be understood? The subjective intention is just purely to put forward the material, which can be understood, rather than the subjective intention being to make a claim. Which of those two is it?
My lord, if we're dealing with the context, I mean, in the context of children, this, of course, is remarkably difficult, because how does one divine either of those positions if you're dealing, say, with as we are in this case, an 8-year-old child? It may be that the 8-year-old child can actively indicate a fear of persecution that would meet the approach that I've sought to identify, but that it's likely that it's going to be in pretty limited terms.
Yes.
Can I take your lordships to the additional bundle of materials that was provided yesterday? And on this point, if I may, to page 3 of a document that is headed "The Detailed Explanation of the Amended Proposal." It's at page 40 of those additional materials. And this is
an explanation of the recast directive.
Yes.
Yes.
And this provides some potentially added information about what is required by the sub-paragraph that we've been looking at. And you will see, my lords, that it says, in line with the definition of an application of Article 2B, an application is deemed to be made as soon as a person who can be understood to seek refugee status.
Sorry, which article are you reading?
I'm so sorry, my lord, under Article 6.
Thank you.
Which I think is internal page 3 of that explanatory memorandum.
And which part of Article 6? The note to Article 6?
Second paragraph, which starts the terminology.
Yes, thank you.
And I'm starting at the third sentence. In line with the definition of an application of Article 2B, an application is deemed to be made as soon as a person who can be understood to seek refugee status or subsidiary protection status makes a request for protection from a member state. This act does not require any administrative formalities. Relevant administrative formalities are accomplished when an application is lodged. In line with paragraph 2, member states shall give an effective opportunity to lodge an application as soon as possible, notwithstanding any practical restrictions in line with paragraph 1, to any person who wishes to make an application. I now, my Lord, would, within the same bundle, want to take you to the recast procedures directive. And I want to identify, in the time available to me, the developments within this directive that I say are consistent with international obligations and give a illuminating comparison to the safeguards that I suggested at the outset of my oral submissions. It's in the same bundle, if I may, and it falls just prior to the document that we were looking at. It's the first, it's page 1 or 2 in the, it's page 2 in the bundle. It begins with the recitals that indicate its conception. And I want just to, if I may, my Lords, walk you through some relevant recitals and articles. Recital.
Forgive me, Mr. Deverett, does this replace both previous directives?
No, my Lord, this
Directive.
it simply replaces the procedures directive.
Thank you.
The first port of call, so to speak, is recital 8, please. And within recital 8, we have recited that the Stockholm programme affirmed that people in need of international protection must be ensured access to legally safe and efficient asylum procedures. I then want to rely on recital 12. The main objective of the directive is to further develop the standards for procedures, for the further development of it, for granting, withdrawing international protection with a view to establishing a common asylum procedure in the Union. Recital 15, with respect to the treatment of persons falling within the scope of the directive, member states are bound by obligations under instruments of international law to which they are party. Obviously, we're not party to the United Nations Convention on the Rights of the Child, but we are party to, for example, the Hague Convention, and of course the European Convention. Recital 18, it's in the interest of both member states and applicants for international protection that a decision is made as soon as possible on applications for international protection without prejudice to an adequate and complete examination being carried out. Recital 22, that deals with applicants having, at first instance, free of charge legal and procedural information. Very important, we say, recital 25, that persons in need of protection as refugees or persons eligible for subsidiary protection should have effective access to procedures recital 29, certain applicants may in need of special procedural applicants may be in need of special procedural guarantees due inter alia to their age, which would of course cover children. And then over the page, recital 33 the best interests of the child should be a primary consideration of member states when applying this directive in accordance with the Charter of the Fundamental Rights of the European Union and the 1989 United Nations Convention on the Rights of the Child. In my long run-up, my lord, we obviously went to the UNCRC, and the reason I did that was to establish that the procedural guarantees and safeguards within this took into account those provisions. And then, forgive me, recital 60, please, which is obviously further down. The directive respects the fundamental rights and observes the principles recognised by the Charter. Now, the Charter is not part of the law of this country, but again, this directive takes into account and respects those rights within the Charter. And Article 18 of the Charter, which your lordships don't have, but we could provide it if necessary, deals with the right to asylum, and that indicates, that states, forgive me, that the right to asylum shall be guaranteed with due respect for the rules of the 1951 Geneva Convention. So the thrust of my submission in relation to this is that this directive is steeped in and pays full respect to the obligations, the international obligations, and it expressly records that it's steeped into the international obligations that derive from the European Charter, but also the United Nations Convention of the Rights of the Child. Yes, Lord Leggett.
But where does any of this get to, Mr. Deborah? Because this isn't part of the law. So, you never arrive at the crease to deliver the ball, do you, after your long run-up?
Well, my lord, let me try and make some boundaries, if I can, in relation to this point, because my fundamental point is this, and if I can simply make singles, I'm happy with those too. But my fundamental point distilled is this. If your lordships put in place the safeguards that the Court of Appeal anticipated and endorsed, then which are mirrored by this procedures directive, then there can be no reason, and there should be no reason to accept the defined case of the appellant, because there are already procedural safeguards sufficient, as endorsed by the Court of Appeal, as plainly developed by our European friends, that protect the invisible child, protect the child that needs itself protected. So in the sense of standing by the crease and waiting for the ball to be bowled and trying to make a boundary or a single, that is the fundamental submission that I make in relation to this. I, of course, accept that we didn't opt into this, and I accept that this is something that doesn't apply, but I use it to confirm the appropriateness of the procedural safeguards that the Court of Appeal put in place. If our European friends are satisfied, having regard to the international obligations that they are required to follow, as are we, that the safeguards within this directive meet the very concerns that your lordships are considering, then mutatis mutandis, so should we be. And the safeguards that I identified at the outset of my presentation are such to meet those needed protections. It may be an unorthodox way of batting, but I still say I make some runs. And that's why I seek to rely on the detail of this directive. Yes.
I have difficulty. If the law is that an application is understood to be an application, what when we have to apply the law. All the procedural safeguards that we could implement can't remove that requirement. And you're not arguing that an application that isn't understood to be one is inappropriate.
No.
So, I mean, I don't understand how these procedural safeguards address that issue at all.
Well, my lord, can I try and develop them and see whether they have a better propensity to hit the target? And if they don't at the end of the day, then obviously I've failed to save your lordships. I was taking your lordships, and I don't know whether Lord Leggett wanted to ask a further question. No, thank you. I was taking your lordships to the articles within this directive to identify the developed way that our European cousins have moved the directive on. And could I take your lordships to Article 2, Article 2, and you'll identify that there's been some development at Article 2b, where the application, well, not development, but a repetition, again, of those words who can be understood to seek refugee status or subsidiary protection status. And that's, again, the application for international protection, or an application being a request. Within the directive at Article 7, there is a specific procedural guarantees to minors, and they can be seen at Article 7 in a developed form. So if I could take your lordships to Article 7, Article 7.1, member states should ensure that each adult with legal capacity has the right to make an application for international protection on his or her behalf. And then critically, we say, in terms of the procedural safeguards, and I'm not overlooking Lord Stevens's point, but I do want to develop this. Critically, we say Article 7.3, member states shall ensure that a minor has the right to make an application for international protection, either on his or her own behalf, if they have legal capacity, or through his or her parents, or other adult, family members, or an adult responsible for him or her, whether by law or by the practice of the member state concerned or through a representative. So that is a new provision that develops the position from the Procedures Directive as transposed to provide the right, for example, to a children's guardian to make an application on behalf of the child. And then in this recast directive, Article 9, which replicates the provision under Article 7 of the previous Procedures Directive, that applicants shall be allowed to remain in the member state for the sole purpose of the procedure. So we do seek to rely on this directive to indicate the guarantees, the procedural safeguards that have been put in place. And you'll see that particular guarantees are afforded to unaccompanied minors. So if you go to Article 25, unaccompanied minors are provided with particular guarantees as set out there. And in relation to unaccompanied minors, if I could just let your lordships see Article 25(1). And then Article 25(6). The best interests of the child shall be a primary consideration for member states when implementing the directive. And can I take your lordships next, then, within that context, to the UNHCR handbook, which is at page
I think Lord Hampden's got a question.
2000.
Question from Lord Hampden.
So sorry.
Mr. Dever, as far as I'm aware, in your case, no reliance is placed on the recast directive. I would certainly find it helpful if you could set out on one piece of paper, one side of a piece of paper, what points you say you derive from this. I think that would be helpful.
My Lord, we'll do that overnight, of course. Can I take your lordships next to the UNHCR handbook, which is at page 2380. And there, in particular, if we could go first to page 2375. This is at tab 67 of the hard copies. I think your lordships were taken to this by Mr. Hussain. Tab 67, page 2375, deals with the principle of family unity. And paragraph 184 states if the head of the family meets the criteria, his dependents are normally granted refugee status according to the principle of family unity. This, of course, deals with, I think, the question of derivative refugee status. It's obvious, however, that formal refugee status should not be granted to a dependent if this is incompatible with his personal legal status, goes on to say. But what I seek to rely on is the provision at the commentary at page 2380 under the heading unaccompanied minors. And I say that, again, in the same way as we've looked at in the directive, in terms of establishing safeguards and ways in which these cases can march hand in hand, some assistance may be derived from how unaccompanied minors are treated. And in this regard, I'd ask your lordships to read paragraph 214. And there you see that it's suggested that a child not being legally independent should, if appropriate, have a guardian appointed whose task it would be to make a decision that would be in the minor's best interests. In the absence of parents or of a legally appointed guardian, it's for the authorities to ensure that the interests of an applicant for refugee status who is a minor are fully safeguarded. And as part of my suggestion at the outset, the joinder of the children at the beginning of the process would provide that ability for a guardian to make an application on behalf of the child, and indeed to receive, as Mr. Payne has identified, the information that derives from the mother or father's asylum file, and to therefore make decisions and or cooperate and liaise with the Secretary of State. So that safeguard that I've identified at the beginning is supported by the handbook of the UNHCR. I want to now, if I may, my lords, to turn to the immigration rules and just make a few remarks about those rules. They are at tab 14, electronic page 675. And I apologise to the court if I'm going over ground that Mr. Payne covered yesterday, but I do so to assist the court and not in any way to be repetitive or to be an irritant. My lords, at page 676, the introduction to the immigration rules, the procedures shall apply to the consideration of admissible applications for asylum and humanitarian protection. So we say that their application is confined, as is identified at the beginning. In terms of the position in relation to dependents, your attention has been drawn to Rule 329. That's page 677. Until an asylum application has been determined, and there's been, of course, comment about when that is, no action will be taken to require the departure of the asylum applicant or their dependents from the United Kingdom. And we agree with the Secretary of State where they say that that is a practice that they have developed and applied. It's obviously a practice that you can... Lord Leggett.
Sorry, I didn't mean to interrupt you in mid-flow. I just wanted some help as to who counts as a dependent, because you did raise a point earlier that there could be a situation where one parent abducts a child who is not living with that parent. Would that child still count as a dependent in that example?
Very much so, my lord. Very much so, because that is a dependent, unless I'm corrected, and I'm happy to be corrected, but a dependent. The rules obviously transposed the particulars that needed to be transposed within the directives, save for those particulars that are included in the regulations that don't need to trouble us. Within, if one goes back to the directives, one sees the definitions of family members. And those family members include, and that they're defined, for example, in the qualification directive, that's at page 563, as including, well, sorry, I put that word in. They are defined as the spouse of a beneficiary or subsidiary protection status, or his or her unmarried partner in a stable relationship. So they go obviously beyond a mere child. So to go back to your lordship's point, the example that I give is an example where the parent who doesn't really have any connection with the child could compromise the child's welfare by removing and then relying on the benefits.
That's the point, but the short answer to my question is it that every child is automatically dependent, whatever their actual relationship with the parent? Is that yes. What the position is? That's
my understanding, yes.
Thank you.
So paragraph Rule 329, that's the policy. It's obviously the policy that is consistent with the asylum instruction manual, the May 2014 document that we've looked at, and which I seek to criticise in the context of Lord Stevens.
The reference to applicant in the Rule 329, is that a reference to somebody who's understood to be an applicant?
If the immigration rules are regarded to be an effective and appropriate transposition of the directives, as this country is required, then it must follow that it ought to.
Yeah.
In addition to the practice that is encapsulated with Rule 329, Lords, you will be aware of the terms of Section 77 of the Nationality, Immigration and Asylum Act, which is at page 674, so shortly just before the immigration rules, which we've just been looking at. And that deals with the situation of removal whilst a claim for asylum is pending. And you'll see at page 674, tab 13, that section 77 prohibits a removal while a person's claim for asylum is pending. That individual may not be removed from the United Kingdom in accordance with the provision of the Immigration Acts, or required to leave the United Kingdom in accordance with the provision of the Immigration Acts. But then, of course, that's qualified by subsection 4. And your lordships will have picked up that our case on ground 2, which is the ground relating to whether the court should determine cases, seek support from this, in the sense that if the Secretary of State is able and expressly able to carry out preparatory acts for a removal, again, mutatis mutandis, a judge in Hague Convention proceedings ought to be able to do the same. At all events, Lord Stevens.
I do apologise for interrupting you again, but the 2002 Act, of course, was before the directives, and do we now interpret it in light of the directives as while a person's claim for asylum, would that include a claim which is understood to be a claim?
Well, in response to that, one would have to go, and I don't have a quick response to it, but one would have to go to the materials that the Secretary of State has provided, where they set out the way in which the Qualification Directive and the Procedures Directive have been transposed into law by virtue of the immigration rules. And they're contained in the bundle in the Secretary of State's, they're in the supplementary bundle, I'd have to check that and come back on that point, but I can do that pretty rapidly. But within those materials, there is an annex to, I think, is it the immigration rules, that shows the way in which the immigration rules have been transposed, and that which needed to be amended in the light of the different directives. But I'd need to check whether there is reliance, and I recall that there is certainly reference to section 77, but whether that arises as a result of what's contained within the Procedures Directive. And to answer the question, does that therefore mean, does that cover a request that's understood to be. But we will respond very shortly on that point, if we may. Lord Leggett.
So just before you go on, does this apply at all to somebody who's ordered to be returned under the Hague Convention? Does it bar to their removal?
Well, we would say not, because it is confined to the administrative or the processes undertaken by the Secretary of State. And in that regard, I want to take your lordships to the case, the Court of Appeal case of RES, which is an electronic bundle 2030, tab 50 for the people who are using hard copies. But this is a decision of the Court of Appeal where Lord Justice Laws provides, we would say, helpful analysis of the effect of that provision or its predecessor, in fact, and the particular rule that we've been looking at. That's the rule that concerns dependents. And if I could just take your lordships to the case of RES, it's electronic bundle page 2030. The Constitution was Lord Justice Laws. Forgive me, the Constitution was Lord Justice Thorpe, Lord Justice Laws, and Lord Justice Riggs. Lord Justice Laws gave the lead judgment. Page 2032 identifies the context in which this analysis took place. That context was an application made by a father under the wardship jurisdiction, so pursuant to the inherent jurisdiction of the High Court, to return two children, I think it was, to India at that stage having not ratified the 1980 Hague Convention. The mother, and only the mother, made an application for asylum. See paragraph 3, page 2032. There wasn't, as is recorded, a separate claim on behalf of the boys, but she named them, my lords, as her dependents. The Secretary of State refused the mother's claim, and the mother thereafter, paragraph 4, made an appeal. Meanwhile, the father made an application for the return of the children under the inherent jurisdiction. It came before Mr. Justice Bennett, and the Court of Appeal considered the relevant provisions of the predecessor to section 77 at paragraph 7. It was then section 15 of the 1999 Act, and you'll see that it was in similar terms. That's set out at paragraph 7. You'll then see, my lords, at paragraph 8 that the particular rule in the immigration rules was set out too, which is in similar terms. And you will see that Lord Justice Laws's analysis begins in earnest at paragraph 10, side letter E, page 2034. I start with the observation that the language of section 15 has the expression, he may not be removed or required to leave the United Kingdom. He then refers back to the Immigration Act 1971, that being the first statute in the corpus of modern immigration law. He then reviews a number of different acts, paragraph 11 onwards, the judgment that he provides on this issue is encapsulated at paragraph 21, where he determines this review of the statutory materials shows in my judgment that the language of remove and required to leave are terms of art in the law of immigration. They are replicated throughout this part of the 1999 Act and are the very language of section 15 itself. He goes on to say, these materials seem to me powerfully to demonstrate that the prohibition in section 15 is directed to the immigration authorities, who are of course part of the executive, and imposes upon them a most important negative duty in the context of their administration of immigration law and practice in the United Kingdom. The section is not intended to occupy any wider canvas. It cannot, I think, sensibly be read as creating a substantial exception or any exception to the obligations arising under Article 12 of the Hague Convention, or be intended to circumscribe the duty and discretion of a judge exercising the wardship jurisdiction. And in parentheses, I add that your lordships will be aware that within the bundles of authorities, there are some authorities where other states, in particular the United States and Canada, have considered issues relating to the interrelationship between immigration law and the 1980 Hague Convention. And they themselves have located their ability to return a child, notwithstanding the application of that child and or the parent for asylum, under the fact that the requirements of non-refoulement bind the executive specifically and not, for example, the judge adjudicating upon Hague Convention proceedings. Yes, Lord Stevens.
I can understand that being the line in Ray S, but that would also cover a case where there was an application by a child before the Secretary of State, and there's no respondent's notice to contend that the High Court then could just return the child to South Africa in this case, irrespective of what the outcome is before the Secretary of State.
Yes.
I mean, that issue, as I understand it, hasn't been advanced relying upon Reyes.
That has not been advanced for the reasons that you have articulated. And I simply emphasize that for the court's attention, not to further my own case, but to identify the position in other countries, and also, my lords, the concerns that have been presented by some of the other interveners and some of the points that they make. But for the avoidance of doubt, I don't seek to rely on Ries to bring in a further line of argument that I haven't had permission to run. But I do rely on it to make the point that the immigration rules in section 77 and the attendant obligations in section 78A, which fight against children particularly, are confined on one view to the administration of immigration control and procedure by the Secretary of State. And just continuing the line of argument relying on and considering Re S, can I take your lordships to paragraph 25, if I may, page 2037. And there Lord Justice Laws reflects upon the, as he puts it, separate question, how far the family court, paragraph 25, page 2037, fourth line, forgive me, how far the family court, acting under the Hague Convention or the wardship jurisdiction, is obliged to take account of or comply with Article 33 seen as a freestanding instrument. He then indicates that then that is a question they don't need to decide. He then goes on at paragraph 27 to make a further point. Even if section 15, which as we know is the predecessor to section 77, may apply to family court decisions, it would not, in my judgment, in any event serve to prevent the boys being sent to India. They are not themselves asylum applicants or appellants. They are not a person within the meaning of section 15. Dependents are indeed protected by the law when a claim for asylum is made by the mother. That's done by paragraph 329 in the immigration laws, which I've read. And so he himself there did not see that there was a prohibition that resulted from either section 15 or paragraph 329 to prevent, in that case, a return under the wardship, the inherent jurisdiction, wardship being within that, or indeed pursuant to Article 12 of the convention with which we are concerned, the Hague Convention. That was his analysis.
Isn't he saying this paragraph, there is protection under paragraph 329 for the children?
But that's confined, is he not saying, to the practice of the application of the immigration rules and procedures. What he doesn't say is that prevents a return to India, because that's what happens in this case.
But that's because there was at the appeal stage. But at an earlier stage, paragraph 329 surely would have applied to the dependents.
I'm not sure I take that from what he says.
It seems to me he's drawing a distinction between the applicant under section 15 and says that doesn't cover the boys. That protection is given by paragraph 329.
Well, I don't see, my lord, that is his interpretation because of the reasons that I've sought to make. But in this case, the children were returned, and the thrust of my submission is supported by the fact that he records, as we have seen at paragraph 21, that these matters fall within the confined landscape of immigration law. They don't occupy a wider canvas. Might that be a convenient point to down tools?
Yes, I think so, Mr. Devereux. Oh, yes, Mr. Payne.
Well, my lord, might I just raise three matters, please? The first is that on behalf of the Secretary is very concerned at the court's invitation to the mother and father. I mean, these are two private parties to agree steps which the High Court could take to regulate the actions of the Secretary of State.
No, I think you've misunderstood the position, Mr. Payne. We're not inviting the private parties to agree steps at all. We're inviting each of them independently to put forward their proposals to assist the court as to the steps which might be taken.
Absolutely, my lord. Sorry, I beg your pardon, my lord. That was my poor for submissions. But the
And Mr. Payne, for my own part, I would welcome assistance from anybody. And obviously, the more people see those proposals, the better it is, and the more enduring they could be.
Well, absolutely, my lord. So perhaps I didn't mean to be as aggressive as maybe I've sounded. Well, the point I wanted to make was, insofar as they're going to be proposals which impact on the Secretary of State, the Secretary of State would be grateful for the opportunity to consider those and to make submissions relating to them, because it would seem as the determining authority that would be useful for the court.
Of course, in specifically referring to the mother and the father in relation to that matter, it was simply because they were the parties to the proceedings who have the closer connection with the Hague Convention procedures.
Absolutely, my lord. But it's just
you yourself have concentrated on issue 1 in the course of the presentation of your submissions on behalf of the intervening Secretary of State. But we welcome submissions from any of the interveners or parties in relation to this matter. And of course, the other parties and interveners will all have the opportunity to comment on it.
I'm very grateful, my lord.
I should make absolutely clear, there's no intention here to invite the parties to agree a procedure which might be followed in the future. We're inviting their submissions as to what we might direct should occur in due course.
Absolutely, my lord. And as I said, I'm sorry for the poor way in which I articulated the point. It was simply that because the Secretary of State doesn't have any further entitlement to make oral submissions, perhaps I should have just made the point, as I said, less aggressively, and just wanted to check whether the Secretary of State would be able to make written submissions on the point.
Yes, of
course. Thank you very much, my lord. And in terms of,
before we move on to the second point, I expect that there will, before the end of the hearing tomorrow, be further matters on which we will be inviting submissions in writing as well.
My lord, yes. Might I then just tentatively raise the position of CAFCAS, because having made a suggestion as to what the Secretary of State might be able to do, the position is now that in light of the father having made suggestions as to the role that CAFCAS should play. CAFCAS, as you're aware, my lord, is a statutory body, and we would urge caution in terms of considering what the role CAFCAS might play without CAFCAS being on notice and able to express their view as to the role that they might play. And that sort of goes beyond simply the slightly informal approach that I suggested this morning. So in effect, we're inviting the court to inform or to make sure that CAFCAS is aware of the issue that's being considered, so they can have an opportunity to make comments that they feel appropriate.
We'll give consideration to that point, Mr. Payne.
My lord, the third point is that because a lot of these submissions are being developed orally and aren't reflected in the written arguments, can I urge the court just to be slightly cautious in terms of accepting or proceeding on the basis of some of the criticisms that are made of the Secretary of State. I just want to draw one example, because on behalf of the father, it's suggested that the Secretary of State is behaving in a way that's inconsistent with seeking to expedite convention proceedings by causing difficulties or intervening in terms of disclosure issues. Now, I'm sure that Mr. Deverick's inadvertently didn't mention, or perhaps didn't draw to the court's attention, that in relation to disclosure applications, those disclosure applications are between the parties. And the Secretary only became involved last year and the year before in these applications in order to identify or assist the court at identifying the guiding principles. Now that the principles have been identified, it is for the parties, and often the taking party, who's the one that objects. And although the court sometimes invites the Secretary of State to intervene, it is not the Secretary of State that's causing difficulties or delay in those proceedings. It is the dispute between the parties in relation to disclosure. So that is a matter which perhaps on reflection, you will see that the Secretary of State isn't behaving in a way that's inconsistent or impedes the Hague Convention proceedings. And that is an example of why I think, given when these criticisms are raised orally for the first time, one needs to be cautious about accepting them without the Secretary of State having had an opportunity to reply.
Well, Mr. Payne, we did indicate yesterday that we would want to hear from you on behalf of the Secretary of State precisely what had happened in the history of this particular matter, and why, despite the assurances which had been given and the undertakings given, the matter had taken so long to reach the present stage without any decision having been taken. And you very helpfully addressed that matter this morning.
My Lord, yes, I beg your pardon. And it was Mr. Devereux, I think, was talking about wider cases, not this case, because the Secretary of State didn't get involved until the Court of Appeal. But it was just the suggestion that was a general approach being taken by the Secretary of State in terms of disclosure that was impeding or slowing Hague Convention cases. And that, with respect, isn't correct. And that is a point which my client, Secretary of State, wished to be made clear to the Court.
Thank you. Thank you for drawing it to our attention.
And thank you for your patience, my Lord.
Not at all. Very well. If there's nothing further, we'll now adjourn. We will resume tomorrow morning at 10:30. Mr. Devereux, I think you've got another, well, we'll be back on the old timetable, so you've got another half an hour to go, I think.
I'm very grateful, my Lord. Thank you. Yes.
And we will complete the hearing at 1 o'clock tomorrow. Thank you all very much indeed. Court's adjourned until 10:30 tomorrow morning.